All
right, can everybody hear me?
Yes.
Right. We are back on record in the case of State of Ohio versus Christian Crow, 20 CR 271. The court took recess from the hearing that was set earlier this morning, and did receive by fax the plea form. Okay, we'll see about that. Well, while he looked for that, I know I received it. There was some additional information sent that is of some concern, and so I want to bring that up before we go forward. The previous information that I had received indicated you had started there on the 21st of March, is that correct, Ms. Crow? Okay. And there were, not surprisingly, positive screens, I think the same day, maybe the next day, maybe the 23rd. But I also had reports of positive screens for amphetamine, meth, benzo, buprenorphine, and MDA on the 31st of March. And on the 4th of April, amphetamine and methamphetamine and buprenorphine. And then on April the 7th, amphetamine and methamphetamine and buprenorphine. On the 8th, amphetamine, meth, and buprenorphine, and then there's an FTL, I think, at the top, although that's negative. And then a test on the 11th indicated just buprenorphine. And then I got a copy of the Quest Diagnostics test, and it appears that, I read this correctly, this is what he specified collected on the 8th of April, or then about a week ago, last Thursday. Confirming positive for amphetamine and methamphetamine, positive for norepinephrine, and buprenorphine. Now, buprenorphine is Suboxone. Are you, do you have a prescription for Suboxone in this Crow?
Yes, sir.
Okay. All right. Catherine, you want to talk with her before we go further?
I would, yes.
Okay, I'll put you in a breakout room, Miss Crow, with your attorney, and then once you have finished, you'll then leave the meeting. So when I click on the breakout, it'll probably say something like join. So go ahead and do that. Okay, we're back on the record, on the case of State versus Christian Pro. So, Ms. Hatter's anything you want to bring up?
Yeah, I spoke with Krishna and with her counselor that's there with her today. She indicates that her levels are coming down, and that she also indicated that she has Hep C, I talked to the counselor about this too, that sometimes having liver issues can cause you to test or to retain a test positive even after you stop using. He also indicated that she had been on a pass, but they had revoked any passes for her, so she's not going to, not allow passes, at least for the next 30 days. So I think that those are issues that would address, and I completely understand the court's concerns, so I think those would address that.
When was the pass?
It was within the first couple of weeks that she was there.
All right.
Apparently she was not supposed to have a pass, but there was a newer staff member that wasn't quite aware of that, and that's how it happened.
All right. Okay, well, Ms. Crowe, before we go through the Plea form, I want to explain, I'm going to kind of do this thing, plea form that I have here is not signed. I didn't even look at it.
Okay.
You never signed this, Ms. Crowe?
Yeah.
The one that I have is not signed.
Yeah.
All right. Oh, wait a minute. Okay, here it is, I see it now.
Yeah, sorry.
Okay, got it, it's up in the corner, I thought it was on the other page, all right. Sorry about that. All right. All right, let me explain to you. The purpose of this hearing is to determine if enforcement of an issue into intervention, in lieu of conviction. And then if so, then we'll have this plea. Now, I'm sure your attorney has talked to me about this. And basically, when a person is convicted of or pleads guilty or is found guilty after a trial of a criminal charge, and in this case, a felony, then normally what happens is that person is sentenced. Now, a sentence can be prison, in this case up to 18 months, 26 and 18 months. It could be a fine of up to $5,000. Could be a license suspension of between 6 months and 5 years, or it could be a combination of those. Or it could be community control, or what most people know as probation, in which a person is supervised by the probation department under certain conditions that are set by the court in the sentencing entry. Now, if that happens, then that person has a felony conviction. And, anytime anybody does a background check on you, they show up, or you'll be asked to fill out job applications or perhaps housing applications and things, you would have to respond truthfully that you had a felony conviction. Now, there is an exception to that normal procedure, that when a person enters a plea of guilty or is found guilty, that instead of having a sentencing, the court can admit that person into what's called intervention in lieu of conviction, accept their plea of guilty, but instead of finding them guilty, stay the case for a report from the probation department as to your progress in the program. Now, stay means to stop or to freeze. So the record would show you pled guilty, but it would also show that the court did not make a finding of guilty, and instead, the case is stayed. It can be stayed if there are a couple of qualifications. First, you have to have had a substance use disorder or mental health condition that contributed significantly to the commission of the offense. In this case, that is not a doubt. You have to have the qualified offense, and I see that this agreement is being amended to allow you to plead guilty to a qualified offense as charged. It cannot be an intervention in lieu of conviction because it's a third-degree felony. And then, thirdly, you have to be in a certified drug treatment program, and you are. Now, so you meet the qualifications. So what the court does is, under the law, the court can put you under supervision of the probation department and require you to be in treatment for up to 5 years. I typically order 2 years because I believe that 2 years is going to be a sufficient period of time to determine whether that person is going to be serious about dealing with their addiction, substance use disorder, or mental health issues, or both. Now, one of the conditions of that, under the state law, is that you must remain free from both controlled substances or drugs of abuse and alcohol for at least 1 year. That is a statutory requirement. And the reason I was concerned about what's happening, I'm sure your attorney explained that to you, is that, if you're still testing positive while you're in the facility, if you're going to test positive here in the near future, get another pass to go out and use, then you're not going to be in this program very long. And you're probably wasting your time and everyone else's time, including the treatment facility. So that was my concern. Now, I did study those results, and what this chapter said is borne out by the results, and that they were different, they're getting lower and fewer. But I thought, when I looked at it, there had to have been a pass in there, and that's why I was going to ask that question before this happened brought it up, which suggested to me you got a pass and went out and used it again. And that's one of the reasons that, as I understand it, they're taking away your pass rights for the next 30 days to make sure that doesn't happen. Now, at this point, since you did test negative except for Suboxone on the 12th, 2 days ago, I'm going to accept that for purposes of putting you in the program if that's what you want to do. But I just want to explain to you right now that you need to understand the big advantage in this process is this: even though you plead guilty, if you obey all of the conditions of supervision, which are not as strict as a person who's been convicted of a felony, but there's still restrictions, and you have to report, and there's some other restrictions that they go over with. And if you successfully complete your treatment plan, then the court will, once I receive that result, will dismiss the case against you. So even though you pled guilty, you will not be convicted. And until you are actually plead guilty or found guilty and are sentenced, you don't have a felony conviction, even though the record reflects you pled guilty. So you can truthfully say to people, I am not convicted yet. And then once the charge is dismissed, then the court seals the record. I have to have a hearing to make sure that nothing has happened that would prevent that from being sealed, but the 99% of cases are sealed. And that means that it's wiped off the record, and it won't show up on a future record check, and you can tell people truthfully that you were never convicted of a felony. Now that's a big plus for you, and a big opportunity, because having a felony record, even if you don't go to prison, is not a good thing. And if you end up with a felony conviction, particularly if it starts out early on in this program where you continue to use and fail to apply, then you're most likely going to be convicted and could be sentenced to prison then, or could be sentenced to prison at a future time. You need to understand this is a good opportunity for you, but you better be serious about it. And if you don't think you can stay clean for the next year, then you're wasting everyone's time and yours. So, you think that you are going to do this? That's your intent?
Sure.
Okay. And by the way, when you take your hat off, we are still in court session. Thank you.
Sorry.
That's right. Now, I'm going to hand in or show you this agreement, and this it now has a fax the Hackner law, or from Southern Hope to Hackner, then Hackner, I guess. I think they went in court to me, but I'll hold that up there, and that is your name and your plea form. Is that correct?
Yes, sir.
And this form that we were talking about that you signed earlier.
Yes, sir.
Okay, now page 3, there are signature lines, and near the top there's a signature that says I entered this plea voluntarily. And is that your signature right there?
Yes, sir, it is.
All right, and when did you sign this agreement, Ms. Pro?
I signed it yesterday.
Okay. Now, you've been talking with your attorney before that, is that correct?
I emailed her, that's how we usually speak.
So, did you ask her to explain this or have an opportunity to discuss this form with her to make sure you understand it before you sign it?
No, sir. I read it myself and did it that way.
You read it yourself, okay? Now, do you feel that you need to talk with her about it or ask her any other questions beyond what you've already talked about here this afternoon? I'll give you a chance to talk with her about it.
I just had one question, and it was actually for you. Like, I know this says, with after the year that it's off my record. Now, say, because like I have a career in healthcare, and say, after because I can get a job while I work here, or while I am here, and I didn't know, like, when I go apply for a job, even though it hasn't been that year, do I have to say that I have a felony?
Okay, well, let me clear up a couple things. Number one year isn't magical. 1 year is the minimum time you have to remain drug and alcohol free. I usually put it as 2 years. Although if a person does extremely well and meets all their obligations and pays their court costs, oftentimes I will dismiss it earlier if that's recommended by probation. But to answer your other question is that like, even though you plead guilty, if you apply for a job and ask if you think it's a felony, the answer is no, until you are sentenced. And so now, you probably would be best served to acknowledge that you've been arrested, explain to people you're in treatment. But let me tell you right now that if you don't tell people, employers particularly, they may not look at it very favorably. Whereas I know the people we have in drug court, they go in and tell people what they're doing and the background, just own it. Then we've had quite a few of them that get in court. So that's the situation. So right now, you're not disqualified as a felon until you have a conviction. You're not a felon until unless you have a conviction. So if you plead guilty today, and a year from now you're still doing well, and you apply for a job, you can still say, no, I do not have a felony conviction. Now they ask you if you want pending, yes, because it is still open, but you haven't, even though you pled guilty, you're not convicted. Does that answer your question?
Yes, sir.
Okay. And if there's anything else you need to talk with Ms. Hacker about at any time during this process, just let me know. I'll push you two back to breakout rooms to discuss it privately, all right? Okay. Now, do you think that you fully understand this form, and even though you didn't discuss it in detail with your attorney, that you've read it over and you feel that you're satisfied that you understand it?
Yes, sir.
Okay. And have you been forced or pressured in any way in signing this agreement?
No, sir.
Are you entering into the agreement to plead guilty voluntarily?
Yes, sir.
All right. Now, the agreement, currently you're charged with illegal conveyance of drugs of abuse on the grounds of a specified governmental facility, third-degree felony, carries a possible prison term between 9 and 36 months. And then count 2 is possession of drugs, which is a first-degree misdemeanor. Now, what I'm looking at here in the plea of guilty form is that you are going to plead guilty to a lesser offense of attempted illegal conveyance of drugs of abuse on the grounds of a specified detention facility. And that's an important thing for you to be, because without that, you cannot be in this program. Because what that does is basically what it says that this attempt statute means you try to commit that offense, but you weren't successful. So it basically is that you engage in conduct which is successful would have constituted result in the offense. That reduces the charge then by 1 degree. And so since it's charged as a third-degree felony, it brings it down to a fourth-degree felony, which has a possible prison term between 6 and 18 months, by $5,000. And that then makes you eligible to be admitted into this program. You understand that?
Yes, sir.
Okay. And Ms. Hafner, you and your client are agreeing to the amendment of the indictment to do some.
We are, yes.
All right.
Yes.
And you agree with that, Ms. Crow?
Yes, sir.
Okay. Now, other than this charge, are you facing any felony charges anywhere else?
Yes, sir.
And other than pretrial supervision in this case, are you on any probation, community control, parole, or bush release control for a felony?
Yes, sir.
Right? Now, if you plead guilty to this charge, you will be placed, as I indicated, on community control under terms that have been set by the court that the probation department administers for a period of 2 years. I could make it up to 5 years under the law, but I go with 2. Although I can extend it if I think it is appropriate down the road. And again, it will, one of the key requirements will be to abstain from the use of drugs or alcohol for a period of at least a year. Now, as I indicated, in the event that it's reported back to me, within that 2-year period, usually, somewhere between 1.5 years and 2 years, that you have successfully completed your treatment, you paid your costs, and you otherwise complied with the conditions, then at that time the court will dismiss the charge against you and set it for a hearing to seal the record, and will, in all likelihood, seal the record. However, if the probation department feels that you're not in compliance, then they will file a written notice of that with the court and provide you a copy. Then you will have a hearing. You will be represented by an attorney at that hearing. And if the outcome of the hearing is that you have failed to comply with either the treatment program or the conditions of supervision or both, at that time the court can terminate you from the program, and then you'll be found guilty. And then we will have a sentencing hearing. Now, it doesn't necessarily mean even then you go to prison. At that time, the court could put you on community control for a period of up to 5 years under the probation department supervision, but that would be under much more strict and numerous conditions, because then you would have a felony conviction because you were found guilty. The sentence would be community control, not prison. And basically the same process applies as it does with intervention, and that is if they feel you have not complied with the conditions, they file a written notice of that to the court, they give you a copy, have a hearing, and you're entitled to be represented by counsel at that hearing. And if the outcome of the hearing at that time is that you fail to comply, then the court will revoke your community control, then sentence you to prison for between 6 and 18 months and fine $5,000. Now, if that happens, once you complete the prison term imposed by the court, then the law provides that you could be put under what's called post-release control supervision once you complete the prison term. If that happens, that means you'll be supervised under terms set by the adult parole authority by a parole officer, because that state and support has nothing to do with it. And if the parole authority determines that you fail to comply, then they could return you to prison even though you served the entire term set by the court for an additional period of up to half of whatever prison term is imposed for one or more violations. But if you commit another felony while you're under post-release control supervision, then in addition to whatever sentence the judge in that new felony case could impose, the judge could also sentence you to an additional period in this case of 1 year or whatever time left on that period of post-release control, whichever is greater. And if that occurred, that would be served consecutively to the sentence in the new case. Do you understand that? Right now, Ms. Crowe, even if, as I said earlier, if you are convicted, if you end up violating or found guilty, like I said, I could put you under community control, I plan to let that happen. So, but because this is your last chance to stand on a plea of not guilty, there are certain rights you must understand before we go through the case now, or before we go to the plea. Now, first of all, the charges that I said indicates in count 1, on or about March 8, 2020 in this county, you did knowingly convey or attempt to convey onto the grounds of the detention facility at Greenfield Jail. I'm not going to read the rest of the stuff, it's not actual. A drug abuse is defined in ORC 3719.011 Norfolk, in violation of section 2921.36A. And as amended, the amendment would then read that you did that, you knowingly or purposely engaged in conduct which is successful would constitute a result in that offense. So that's the intent. Now, do you understand the amended charge, which you're charged with, what the state said you did, when, where, and how they alleged you did? I didn't hear you.
Yes, sir.
Okay. Do you understand the possible penalties for that offense?
Yes, sir.
Have you discussed the amended charge, the nature of the charge, the evidence in the case, possible legal issues in the case, possible defenses you might try to raise at trial, possible outcomes of a trial with your attorney?
We have emailed about it, Your Honor.
Okay, well, email includes discussion.
Yes,
Okay.
yes, sir.
Thanks for clearing that up. And are you satisfied with her advice and confidence in this matter of representing?
Yes, sir.
Has anyone threatened you to issue plea guilty here today?
Yes, sir.
Now, you have a prescription for Suboxone, right?
Yes, sir.
And other than that, are you taking any prescription drugs?
No, sir.
And Suboxone's not interfering with your ability to understand what's going on, or to communicate, or understand what you're reading and went through this screen. Okay. Now, on page 2 of the agreement, it says, defendant will enter plea guilty to count 1 as amended, state recommends intervention, lieu conviction. I assume also count 1 or count 2 is being dismissed. Is that correct, Ms. Collins? Normally, I enjoy the sounds of your muting, but I would like to hear on the record that that is correct. You're muted.
Oh, there it went. I couldn't figure out how to get it off. Yes, I do agree to dismiss count 2.
All right, thank you. All right. Does anyone promise you anything other than that to get you to plead guilty here today?
No, sir.
All right. Now, you mentioned earlier you're in the healthcare field. Do you have some sort of a license or certificate from a state board for profession in healthcare?
Yes, I'm a certified STNA, and I'm also a certified phlebotomist.
Okay. Well, like I said, if you plead guilty but are referred to intervention, then you won't have a record. But if something should happen in the future, like you don't comply and you're found guilty and are sentenced, whether you be sentenced to prison or community control or fined or whatever, then at that time the clerk of courts is required by law to send a copy of the conviction to the medical board, and then they could end up taking action on your license. Now, the mere fact that you pled guilty doesn't require us to notify them. I don't know what would happen if they find out about it, but just so you know, if you're found guilty, then we do have to report it to them. We're not saying that they shouldn't do anything, but it's required that we notify them. You understand that?
Yes.
Okay. You have certain constitutional rights you need to understand, because as I indicated earlier, this is the last chance you can stand on the not guilty plea and have a trial. Because you can't go through this program and then end up getting violated and kicked out and found guilty, and then come back and say, I want a trial, because you're going to be found guilty if that happens. So that's why you need to understand the rights now. So the first one is you have a right to an attorney, the staff is appointed to represent you. Now, I don't appoint attorneys simply to work the case out and provide any defense that might be available to you under the law that you wish to provide. So if you decide you don't want to plead guilty, you're still going to be represented by Ms. Haffner. She'll defend you, pleading a trial if that's what you want. You understand that? And under the Constitution, you have a right to have a jury trial as a matter of Ms. Crowe, in which 12 people from Highland County would be selected from a group of citizens from this county that were summoned for jury duty on your trial day. After they were selected, the evidence would be presented, and then they would be instructed on the law, and they would decide by unanimous verdict whether or not to say truth or guilt, or prove beyond reasonable doubt. And the unanimous verdict means all 12 have to agree, one way or the other. Now, if you didn't want to have a jury trial, if you didn't want to plead guilty, you can waive the right. Waive means to give up the right to have a jury trial, and in that case, you would have what's called a court bench trial, meaning that instead of the jury hearing the evidence, it would be the judge who would hear the evidence, apply the law, decide whether or not to state truth or guilt by proof beyond reasonable doubt. You understand that?
Yes, sir.
Right. Under the Constitution, you have a right to confront the witnesses against you and to cross-examine through your attorney. What that means is the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else present. After the prosecutor is done asking questions, your attorney will ask questions that's called cross-examination. The purpose of that would be to bring out evidence and help the rules out of the case. You understand that?
Yes, sir.
Under the Constitution, you have a right to use the power of the court to tell witnesses to come to court to testify for you, like I say. What that means is if you have witnesses you are not certain are going to come in voluntarily, and that your request, the court issues a subpoena, which is a court order, that requires that person to come to court, or persons, come to court to testify on your behalf, even though they don't want to be here, which is the same way that state's witnesses are able to force their witnesses to come to court to testify against you. Do you understand that?
Yes, sir.
Right now, Ms. Crowe, in the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this case at any time, including trial. So no one can ever make you testify. The prosecutor can't, the judge can't, you decide. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time. In fact, no one's even allowed to talk about it. One exception, that is if there's a jury trial and you do not testify. The judge does instruct the jury that because that is your right, they cannot consider it for any purpose. You understand that?
Yes, sir.
Right now, in the Constitution, you're presumed innocent until proven guilty by the state of Ohio on every essential element of this amended charge. What that means is that the burden of proof is on you to prove you're not guilty simply because you've been accused. In fact, under the law, you don't have to present any defense at trial at all. You can, but you're not required to. Whether you do or not, the burden of proof remains on the state to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense charge, which is the highest burden of proof that's known under the law. You understand that?
Yes, sir.
Right now, you originally entered the plea of not guilty. Not guilty plea denied the allegation in the indictment and denied that you committed any crime. And that exercised all the rights that I just described for you we discussed here today. If you change your plea from not guilty to guilty to this amended reduced charge, that's the opposite of not guilty plea. The guilty plea admits the allegations in the indictment, admits the third crime, that you're the one who committed that crime. And that plea waives and gives up all the rights that I described for you today, except your right to have an attorney, which you always have no matter what your plea is. That exception, your plea of guilty, would waive and give up the right to have a jury or court trial. It would waive and give up the right to confront witnesses against you and a cross-examine for your attorney. It would waive and give up the right to use the power of the court to tell the court to testify on your behalf in the same state. It would waive and give up your privilege against self-incrimination because you're the one saying you're guilty, and that's what you punish guilty. It would waive and give up for presumption of innocence because if you say you're guilty, then the state doesn't have to prove that you're guilty. Plead guilty also subjects you to being sentenced immediately by the court. And finally, it waives and gives up any right to file an appeal that you think you may have had up to this point in the case. Now, if I should have ever sentenced you to the maximum sentence or under certain situations, could file an appeal, that would have to be filed within 30 days of your sentencing as you're being filed. You understand all of that?
Yes, sir.
And are you a U.S. citizen, Ms. Crowe?
Yes, sir.
All right, now, do you have any questions about the charge or the possible penalties?
No, sir.
You understand?
Yes, sir.
Have any questions about the plea agreement, the recommendation for intervention, and what the intervention means?
No.
You understand?
Yes.
You understand the process of what will be required of you in order to complete the program successfully?
Yes, sir.
Have you had any questions about any of the constitutional rights I've explained to you?
No, sir.
Do you understand those?
Yes, sir.
Have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No.
You understand?
Yes.
Is there any thing you'd like to speak to Ms. Hacker about before we go any further?
No, sir.
Do you have any questions about anything I've explained to you here today?
No, sir.
Then is it your decision to withdraw your not guilty plea and plead guilty to the reduced charge of attempt to commit the offense in count 1 of the indictment pursuant to the terms of the plea agreement that we just went over here today?
Yes, sir.
And then as to the amended charge, I'll read it as amended on the record, that you engaged in conduct which is on or about March 8, 2020, Huntington, Ohio. You did engage in conduct which is successful, you did knowingly engage in conduct which is successful, would have resulted in the offense of your knowingly conveying or attempting to convey on the grounds of the detention facility of Greenville Jail, a drug of abuse as defined in section 3719.011 of the Ohio Revised Code with Norman, in violation of section 2921.36A2 and 2923.02A in the attempt statute, making that offense the offense of attempted illegal advance of drugs of abuse onto the grounds of a specified government facility, a fourth degree felony, carrying a possible prison term between 6 and 18 months and a fine of $5,000 as you leave.
Okay.
Okay. All right. and I don't have signatures of the attorneys on this form, but, I assume that Ms. Hacker, you were in agreement with this entire thing?
Yes, Your Honor.
Ms. Collins?
Yes, Your Honor.
All right, thank you. All right. The court finds that on this day of the court, the defendant was advised of all their constitutional rights, made knowing himself and voluntary waiver of same pursuant to Rule 11. The plea accepted or declined. The defendant having pled guilty to the fourth degree felony of attempted illegal conveyance of drugs and use them to the ground of attempted or specified detention. So, count 2 is dismissed. Now, based upon the report received, probation department as well as the treatment information the court received, the court finds that the defendant's drug dependence was a factor that led to the criminal activity with which he's been charged, and that rehabilitation through treatment will significantly reduce the likelihood of her committing further criminal offenses. She is in an approved certified treatment program that's appropriate for her situation in the Southern Hope Recovery Center. She is otherwise eligible for community control sanctions. She is not a repeat or dangerous offender, and is otherwise eligible for intervention as I discussed previously on the record. And therefore, it's the judgment of the court that the defendant's plea of guilty is accepted as to the amended charge now 1. And will be filed. However, the court will not make any finding at this time. And instead, this matter will be stayed pending a report from the probation department. It's the word of the court that the motion be granted. It should be put in intervention with the probation program. It should be placed on community control under the supervision control of the probation department for a period of 2 years. Those will be under the conditions that the court has approved. You're to be required to follow those. They will give you copies and go over those with you. You're also be required to successfully complete your intervention plan, which is your residential treatment plan there at Southern Recovery Center, and then the aftercare. And also, particularly, you must abstain from using drugs or alcohol for a period of 1 year. Now, that does apply obviously to prescribed drugs, and normally as part of your medically assisted treatment plan, so that's appropriate. Or there should be a future problem that you would need to have medication for. It doesn't apply to that so long as you take it in accordance with your prescription. Now, you're also required, as I said, to pay all the other conditions the court has set and pay the court costs of these proceedings. Now, in the event that it's alleged that you have failed to comply with these conditions, then the probation department will file a written notice at the court, and you will be served with a copy. There will be a hearing, and you will be represented by an attorney at that hearing. And in the outcome of that hearing, whether it be that you fail to complete or comply with your treatment program, or whether you fail to comply with the conditions of supervision, or both, if the outcome of that is that's finding of the court, then at that time, the court will reactivate the case, you will be found guilty, and at that time, you will be sentenced. Now, if that occurs, then it's possible that could be community control for an additional 5 years under different conditions as I explained, or it could be a prison term between 6 and 18 months and a fine of $5,000. As I explained earlier, if that occurs, then on completion of that sentence, you could be put under closely controlled supervision for a period of up to 3 years under a term set by the parole authority, and if you violate those, then you return to prison for up to half of your prison term for one or more violations. But if you committed a felony, then you can be subject to be sentenced for committing a felony while under post-release control. In this case, an additional period of 1 year where time left on that period of post-release control, whichever greater that occurred, that is their second to be sentenced again. All right, so anything further for counsel?
Thank you, Your Honor.
All right, that completes the case then for now. We stay pending a report from probation. Mr. Archie, you want her to call you after we get done here?
Yes, please.
All right, so you need to call me immediately after we complete the log off from this hearing, because you'll be under a different type of supervision, and we'll need to be able to go over that stuff with you, and you'll be reporting to them. So, but you're not under house arrest anymore, only pretrial supervision.